Hi guys, we're going to talk about chapter 6, and this is going to really focus in on legal and ethical guidelines for safe practices for our nurses that are in our psychiatric settings. So we're going to get started. First thing we need to do is define some of our ethical concepts. Our ethical concepts include ethics, bioethics, and ethical dilemma. When we think about ethics, this is the study of philosophical beliefs about what is considered right or wrong in a society. Because ethics are philosophical and involve values and morals, there's frequently no clear-cut, simple resolution to an ethical dilemma. Bioethics is used in relation to ethical dilemmas surrounding healthcare. And then ethical dilemma is that conflict between two or more courses of action, each with a favorable and unfavorable consequences. Nurses are often confronted with ethical dilemmas regarding patient care. This slide should just be review for you on those bioethical principles. There are 6 of them that I just want you to be familiar with. Autonomy, remembering respecting the rights of others to make their own decisions. Beneficence, the duty to promote good. Non-maleficence is doing no harm to the patient. There's a slight difference there. Justice is distributing resources of care equally. Fidelity is maintaining loyalty and commitment, doing no wrong to a patient. And then veracity is that truthfulness, always telling the truth. So what are some evolving ethical issues in our psychiatric care settings? We can think about pharmacokinetic testing. It's used to help identify which antidepressant to use on specific patients based off of a DNA profile, with the goal of eliminating trial and error and improving recovery time. Really, the literature and the FDA do not support this because of the lack of clinical evidence. Issues of non-maleficence can be involved. If the tests are not useful, then potential harm outweighs that benefit. The other one we can think about is predictive psychiatry. Stigmatization. So we can think about genetic testing could prevent an individual from getting a job. Or if we have genetic testing and an employee finds out that an employer has an aunt with schizophrenia, they could also be fired from their job because of that familial trait. There's a lot of issues with autonomy because of that right to know or not know of genetic tendencies in health. Genome scans. Once we're done with the support of a provider, you get that genome scan, you go to your provider, you get the results, and you have a lot of support. Now you can do genome scans in the home setting. You're alone, you get the results, and you have no emotional support with those results. So just some issues that we can think about moving forward in our psychiatric world. So what are some of the voluntary admission and involuntary commitment are a couple that we just want to hit on. As far as voluntary admission, this is sought by the patient or the guardian. The patient is considered competent. They have a right to request and obtain release, but before being released, they must be reevaluated at that time so that the provider can initiate any involuntary admission if that's necessary. Involuntary commitment is without the patient's consent, so they are entering a mental health facility against their will for an indefinite period of time. Usually 2 medical professionals collaborate and they agree for this admission, or a family member can document why the patient may be at harm to themselves or for others. Legal counsel could be involved if the patient chooses. If the patient is not released by a judge, then involuntary admission proceeds. If we're thinking about emergency commitment, which is just a temporary admission, this is typically done so we can observe, diagnose, and treat those that may or may not be at harm to themselves or others. It's usually a 24 to 96 hour time frame. These are people that might be confused or have some dementia escalating. They might be, it might be a court hearing if they need to be discharged. So a lot of this is just a quick emergency commitment. So it's a temporary admission for these type of patients. Due process and involuntary commitment. There's a couple of things we could talk about on this slide. The writ of habeas corpus, which means a formal written order to free the person. Patients who believe they are being held without just cause can file a petition for a writ of habeas corpus, which just means it's a formal written order to free the person. The writ of habeas corpus is the procedural mechanism used to challenge unlawful detention by the government. It is the least restrictive alternative doctrine, which mandates, least restrictive alternative document, is another one. And it helps care providers take the least drastic action to achieve a specific purpose. So, for example, if you can treat someone safely for depression on an outpatient basis, hospitalization would be too restrictive and unnecessary. So in that case, the assisted outpatient treatment could be legally mandated in certain cases. Discharge procedures, we always know that discharge starts with admission. When our patient gets admitted, where do we want to see them at discharge? So unconditional release usually requires outpatient treatment for a specified period of time to determine if the patient is going to be compliant with their medication regimen and can they meet their basic needs, and are they able to reintegrate back safely into society. Unconditional release is termination of the patient from the facility. There's no regulations of either party. Release against medical advice or AMAs. Treatment is beneficial, but there's no compelling reason to continue their stay. An AMA discharge may present an ethical dilemma for some clinicians. On one hand, patients' autonomy and their right to refuse treatment support the patient's wishes for that discharge. But on the other hand, the clinician's beneficence would support benefiting and promoting good, which includes protecting that patient. So AMAs are really challenging as far as we really want you to be seen, but we can't force you to be seen. So what are some of the patient's rights under the law? The first one we can talk about is right to treatment, which means that the environment needs to be humane. The staff must be qualified and the care is individualized for that patient. Right to refuse treatment, they can withhold or withdraw consent at any time. This is where medication can come into play. Even though a patient is involuntarily admitted, does not mean that they are forced to take medications, but some criteria may alter that if the patient is in an emergency situation. The right to informed consent, meaning a physician provides information regarding a procedure before it's done. Risks, benefits, and alternative treatments are reviewed, and then informed consent can be signed. If the patient is deemed competent. So in saying all of this, informed consent is given to those that are able to make the decision and are competent. If the patient is deemed incompetent, then it's going to go to the guardian. That could be a spouse, an adult child, grandchild, parent, adult sibling, someone that's more competent. If none of these are available, then the court will appoint one of those. Rights regarding psychiatric advance directives. This is just clarifying the treatment preferences. There's a document that's prepared when the patient is well and then can identify their wishes regarding treatment decisions. The rights regarding restraints and seclusion. History of restraint and seclusion has really been marked with abuse, overuse, and punishment, and we really don't want to promote that. And by law, we really can't. So reduce this, it's that reduction in movement of the patient. Chemical restraints are medications or doses of medications that are not being used for the patient's condition. Chemical interventions are usually less restrictive than physical or mechanical interventions, but we're still inhibiting their ability to think clearly. Seclusion is confining a patient to a room against their will, leaving them alone, preventing them from leaving, And this is usually done if the patients are endangering themselves or others. But seclusion can be requested by the patient, and that's usually just considered a timeout. But the door is left open. They can come and go as they please. So what are some considerations as far as nurses? What can we do before using seclusion and restraints? We can think about verbally intervening, maybe talking them off the ledge, asking them for their cooperation. Maybe we just need to reduce the stimulation, turn the monitor off, turn the TV off, dim the lights, so reduce some of that stimulation. Make sure you're actively listening, you're hearing the patient, and what are they saying. Maybe provide some type of diversion, and then maybe offer those as needed PRN medications before we just real quick just lock them to the bed or shut the door and put them in seclusion. Maybe there's some things that we could consider before doing all of that. When we think about right to confidentiality, the healthcare provider is prohibited to disclose any privileged information without the patient's consent. Confidentiality is an ethical responsibility of healthcare professionals that prohibits the disclosure of privileged information without the patient knowing. So what are some of the exceptions to the rule, though? We do have the duty to warn and protect third parties. This usually includes those that have said, like, oh, when I get out of here, I'm going to go kill my mom. Okay, we probably need to let the mom know, or we need to let the authorities know. So that's, if we need to protect a third party, that's when confidentiality could have an exception to that rule. Child and elderly abuse reporting statutes can also be an exception to that rule. So if you're seeing child or adult abuse, we need to definitely say something at that point. So let's get into laws relevant to psychiatric. Tort law is the big one that we're going to talk about. And this is any wrongful act, intentional or accidental, that results in an injury to another. An intentional tort is the willful or intentional act that violates another person's right or property. So the five that we'll talk about is assault is an intentional tort. Assault is that verbal threat, trying to make someone fearful. Battery is the actual harm or offensive touching of another person. So sometimes you hear assault and battery. So they threatened them, I'm going to hit you with this bat, and then they actually hit him with the bat. That's assault and battery. If they just say they're going to hit him with a bat, they don't actually do it. It's just assault. False imprisonment occurs when a person is confined in a limited area. This could include restraints and seclusion. Medications that act as chemical restraints could also fit in this category. Invasion of privacy is just breaking that confidentiality when it's unnecessary. And then defamation of character is slander or libel. Slander is the talking about a person to a group and a crowd. Libel is actually the writing or the printing of the information, and then intentionally or unintentionally sharing it outside of that professional setting. If we're thinking about unintentional tort, these are unintended acts against another that produce injury or harm, and those two that we can think about are negligence and malpractice. So 5 elements to prove negligence. Duty is when the nurse represents themselves as capable and they actually are not capable. Breach of duty is when nursing performance falls below the standard of care and puts that patient at risk. Cause in fact is sometimes known as actual cause and may be evaluated by asking the question, if it were not for what this nurse did or didn't do, would this injury have occurred? Proximate cause or legal cause is determined by whether the event was foreseeable, and then damages could include like loss of earning, medical expenses, property damage, right? If we are treating a patient that doesn't need to be treated for that extended period of time, they're not going back to their job to make money, and they've now racked up a bunch of medical expenses, that would be considered damages. So some of the standards for nursing care. Our nursing boards are our state governmental agencies that regulate nursing practice. Our professional associations elevate the practice of its member by setting standards of excellence. Institutional policies and procedures often define criteria for care. These criteria can be used during legal proceedings to prove that a nurse met or failed to meet them. A weakness of this method is that the hospital's policy just could be substandard. And then custom as a standard of care can be used as evidence. In the absence of written policy on the use of restraints, testimony might be offered regarding the customary use of restraint in an emergency situation in which the combative, violent, or confused patient poses a threat or harm to themselves. So that could be a custom standard of care. So acting on questionable practice, I think the big one is negligence, irresponsibility, or impairment. We have the duty as nurses, if we are working with another provider or nurse or care assistant, whomever, that is being negligent, irresponsible, could be impaired, we have the duty to intervene. We have to intervene, we have to report it. If we don't report the incompetence, the impairment, or even the criminal activity, meaning you just saw a nurse go to the Pyxis, take out a narcotic and stick it in her pocket, or you just saw a nurse put a pillow over a patient's head, we have the duty to intervene and then report it. If we don't report it, we are just as guilty as the person that is being negligent, irresponsible, impaired, incompetent, all of that good stuff. So you have to act on any questionable practice for your patient's sakes. And then we have to very carefully document all of that. A record's usefulness is determined by how accurately and completely documented it portrays the patient's behavioral status at the time it was written. This could include your negligence of your nurse, your negligence of your doctor, your criminal activity, whatever you see, it has to be documented. And it has to be documented accurately and completely so that it portrays the situation that you are in. So why do we have those documentations? It manages the data, communication, reduces errors, right? You want to do it as quickly as possible. You don't want to do it the next day because you're going to miss some small details. Federal privacy laws on access. If you don't document it, it didn't happen. So make sure you're documenting everything accurately. And you'll hear that over and over again from all of us. If you don't document it, that didn't happen, even though it might have happened. You may also find some violence in our psychiatric setting. I'm going to be quite honest, it could be outside of your psychiatric setting as well. Nurses that work in healthcare always have the potential of being in a violent situation. So you have to just make sure that if you're in that situation, maintain as much safety as possible. Make sure you're always documenting that patient's potential for violence and passing that information along to each nurse after. Communicate any observations that you might see, right? I might be assigned to that patient that could be violent, but if I'm in another room and another nurse sees an observation that may be leading to escalation, it would be nice for that nurse to let their friends know. Usually a prosecutor will not bring charges against disoriented, delirious, psychotic, or otherwise mentally impaired patients. However, violent patients, friends or patients, family members who are aware of their actions can be charged with serious crimes if they are violent in the setting. And that concludes chapter 6. If you have any questions, shoot me an email or we can chat about it in class. Thanks, guys.